Juris Vodcast with Scott Pearce.
A deeply divided California Supreme Court has held that the state has failed to show that the traditional definition of marriage is necessary to serve a compelling state interest. This probably means that, at least for a time, same-sex marriage will be legal in California. It is likely that efforts will be made to amend the California Constitution to ban the practice once again. This decision is interesting because the court approaches the issue differently than have other state Supreme Courts. It is settled law in California that a challenged statute will be interpreted based on the already existing statutory scheme that is present for a particular issue. In this case, the court did the analysis and concluded that since California already allows same-sex partners to assume the rights and duties of married partners, it would be unconstitutional to deny them the right to marry. The California court explicitly states that it is not addressing the question of whether or not, as a matter of policy, same-sex unions should be called marriages, but instead whether the failure of the state legislature to designate these domestic partnerships as marriages violates the California Constitution. The court refers to its own decision in the 1948 case of Pearce versus Sharp. That's the case that overturned California's ban on interracial marriages for violating the fundamental right to marry. For years, advocates of same-sex marriage have compared their situation to that of interracial couples. The California majority agrees with this argument. Next, the court finds it important that sexual orientation has become a category that is protected under civil rights law. This equal protection argument is one more reason why the majority has found the ban on same-sex unions to violate the California Constitution. The majority decision is an extraordinary document, well-written and scholarly. It includes a splendid history of marriage in California law. The dissent is worthy of careful study, too. Essentially, the dissent contends that the majority violates the separation of powers, with the court acting in this decision as a legislative body. Although this is not an unreasonable argument, I'd say the majority has the better position. Their analysis is precise, well-reasoned, and astute. It's worth noting that all the justices are doing in this case is arguing over the word marriage. Gay and lesbian couples are obtaining the same civil rights as other couples, one state at a time, across the country. In substance, same-sex marriage is becoming normal across the country and throughout the Western world. As one who loves freedom, this is my idea of progress.
Juris Vodcast is a production of Nuclear Podcasting. Creative Commons Attribution Non-Commercial No Derivatives.